I hope you have had time to organize your team. You can now start.
Yeah.
As I said, you have 5 hours.
Yes.
The others have 1.5 hours, 1.5 hours. If you can save, please. You don't have to finish all the 5 hours.
Yes.
If you can save a bit of time, it will be great for us.
Indeed, my Lord, from the ruling you just made, for which we are grateful, it will enable me to shorten my submissions. Because there are a lot of stuff which we didn't submit with the court by reading the record came out in the ruling. Yeah, my Lords, let me just, for a start, draw the court's attention that the petitioners are here, Raila Amolo Odinga and Kalonzo Musyoka, together with the leadership of the National Super Alliance. There's also present in court the leadership from the leadership of the party opposite, Jubilee Party. I'm saying this just to confirm that there's been access to the court by the parties, and I think that is an important point to make, and we are grateful for that. Now, my Lord, this matter before the court, the petition, was filed on the 18th of August, 2017. My Lord, the averments contained in the petition are not worth repetition because of time, and the reliefs also are quite specific, but I would want to say that the petition is grounded on Article 140 of the Constitution, as read with Article 163, sub-Article 3 of the Constitution, that confers exclusive jurisdiction to hear and determine the presidential election petition to this court. My Lord, in saying so, it is important to note, particularly on matters that are raised in my submissions, or our submissions, that the jurisdiction of this court, as set out in Section 3 of the Supreme Court Act, is quite instructive. And there are 3 points relating to the object of the operation of this court as set out in Section 3 of the Supreme Court Act. And the first one, 3A, is to assert the supremacy of the Constitution and the sovereignty of the people. My Lord, I think this is very fundamental. And as you consider this petition, I'd urge your lordships that we crystallize these proceedings in a way that is consistent with this particular objective of the operation of the Supreme Court and its jurisdiction. The second object, which is found in Section 3C, which I think is very important and takes away the jurisprudence of the courts before. I think this is a very transformative postulation of the law as contained in this Section 3C, develop rich jurisprudence that respects Kenya's history and traditions and facilitates its social, economic, and political growth. And I think that is important. I'm going to talk a little bit about that later in my submissions. And D, to enable important constitutional and other legal matters, including matters relating to the transition from the former to the present constitutional dispensation, to be determined having due regard to the circumstances, history, and cultures of the people of Kenya. Now, my Lord, I think it is quite historic that the former Attorney General, who is in our team, Honorable Amos Wako, Senior Counsel, is here, as is the present Attorney General, Professor Githu Muigai, because a lot of this history and the jurisprudence and the law that has been developed in the prior period and presently went through their hands. My Lord, talking about history a little bit, I also would not forget to mention that at a particular time in history, Senior Counsel Paul Muite, there was a time when there was a dinner of the Law Society, and he said, I think that was in 1992, if I'm not wrong, that Kenya was now ready for a multi-party democracy. That dinner at the Intercontinental Hotel was attended by judges of the High Court, several judges of the High Court, and out of those remarks, all the judges walked out. That was another time in Kenya, which is quite different from this time in Kenya. My Lord, I've also made a personal journey, and the fact that I'm making these submissions before this court also reminds me that when I was dealing with the case fighting for the tenure of the judges of this court and the issue of the multi-party system in Kenya, I was instructed by the court not to utter any word that would offend the judge, because I had submitted that the security of tenure of judges could not apply effectively to contract judges. So I made my submissions in the presence of police officers and warders that if I uttered any word that the judge thought offended what he thought was right and appropriate, I would be taken down to the cells. This is another time, and I'm happy that those who have dealt with the process of bringing about change are also members of this court. Now, my Lord, having said that, it is also important to go back to the Constitution in respect to the jurisdiction of this court, which is contained, the principles, the guiding principles, contained in Article 159, my Lord, if I'm not wrong. And it relates to the exercise of the judicial authority of this court. And it says in Article 159, sub-article 2, paragraph C, in exercising judicial authority, the courts and tribunals shall be guided by the following principles. And E reads, the purpose and principles of this Constitution shall be protected and promoted. My Lord, what I'm trying to say, that it is part of the function of this court to ensure that the purpose and principles of this Constitution are protected and promoted. And to that extent, Article 81 of the Constitution is important because it relays out the general principles for the electoral system. I'll not go into reading what those principles are, but only to say, in an election petition of this kind, the court would not just look at the interests of the parties that are before the court, that in exercising its jurisdiction under Article 163, sub-article 3, and Article 140 of the Constitution, these principles, the court is under obligation with respect to apply these principles. So that when we talk about transparency, neutrality, accuracy, and accountability, these are not principles that are part of cosmetic value, but they are principles which must be applied by this court. The provisions of Article 86 of the Constitution are more directive in the sense that they spell out how the election should be conducted. And my Lord, again, my lords and my ladies, again, I will not go and read into what it says, but make the following point, that in this particular election, under the old dispensation, we may be more concerned about the quantitative component of the election as conducted. But I think the Constitution now does not give us room to ignore the qualitative and guiding principles that are set out in the Constitution. And you'll be addressed on this point to some length with my learned friend, Mr. Paul Mwangi. But the point I'm trying to make, that it is not enough to look at on the issue as to whether or not any transgressions committed or irregularities committed would have affected the result of the election. When it comes to constitutional principles and when it comes to provisions of the Constitution, if an election is not conducted in accordance with the Constitution, then your lordships need not look at the results in terms of the numerical numbers or votes garnered by the respective candidates. And my lord, this jurisprudence is contained in the civil appeal case that your lordship referred to in the case of Minor KI and the Independent Electoral Commission, particularly the civil appeal number 105 or 2017, where the court did not just look at the history of our electoral system and looked at previous elections, but laid out the importance of ensuring that the principles set out in the Constitution and the law are abided with. And to that extent, my lords, I also would wish to further submit that when any provisions contained in statute are violated, it cannot be considered to be a minor transgression. The election must be conducted in accordance with the law. And that is because, again, under Article 10 of the Constitution, one of the most important principles and values of government is the rule of law. So if there is a transgression that amounts to a violation of any particular section of the law in regard to the election, it cannot be considered to be just a minor transgression or an irregularity. And in order to shorten my presentation, I just want to limit myself in making one demonstration to the court, and then I'll defer to Mr. Otiende Amolo to proceed with the rest of the submissions. My lord, after many amendments in the electoral law, the latest were the amendments which were made towards the end of 2016 and at the beginning of 2017. And this was all in an effort to ensure that the electoral process had integrity and that the system, when tested against principles of accountability, credibility, they would pass the mark. And important in this respect are how we record the results of elections and how the results are declared and the instruments that are used to declare such elections. And our position is that the law is very clear that at every point in an election, the three major tiers, at the polling station, at the constituency, and at the national tallying center, there are functions which are located at those three levels, but the result at every level is borne by the execution of an instrument which is laid out in the law. And to that extent, my lord, I will refer, my lords and my ladies, I refer to Section 39 of the Elections Act as amended. And my lord, they provide as follows. in relation to the elections as held in the polling station and in the other constituency tallying center. But for purposes of what I want to say, probably I'll concentrate on what happens at the constituency, because the law is that the presidential elections is held at the constituency. My Lords, at Section 39, subsection 1A, which came into being by dint of amendment through the Election Laws Amendment Act 2016, in relation to presidential elections, Section 39(1)(a) Roman 2 gives certain responsibilities to the returning officer, and that is collating and announcing the results from each polling station in the constituency for the election of the president, county governor, senator, and county women's representative to the National Assembly. And 3, and this is the important one, submitting in the prescribed form the collated results for the election of the president. The law is very clear that you submit, the returning officer is under duty to submit the collated results in the prescribed form. And the prescribed form is contained in the regulations. In relation to the presidential elections, again, the provisions of Section 39(1)(c) is equally important. For purposes of presidential elections, the Commission shall electronically submit in the prescribed form the tabulated results of an election for the president from the polling station to the constituency and the national tallying center. Now, my Lord, my ladies, in compliance with these provisions, the first and second respondent took some action to ensure that the law as laid out and partly as spelled out in the decision in the minor Kiai case were complied with. And again, for purposes of this case, Your Lordships, I would invite the court to look at the copy, the volume, the notice of motion that my Lords, you have just considered and gave a ruling. My Lords, in that volume contains the specifications of Form 34A and Form 34B. And for purposes, again, of this application, I'll probably just deal with 34B to make the point and invite Your Lordships to look at what was required in respect of Form 34A. That is found on page 260 of the volume that I'm looking at. Now, my Lord, at page 262, it spells out the security features which should be embedded in Form 34B. And that begins from paragraph 5, as found in page 262. And of importance, my Lords, is one, the election result declaration form at the, first of all, at the polling station is spelled out in that part of the document. My lords, if you turn over the page, you will find that the security features that are required to be in these declaration forms include a watermark. They include anti-copying features. They include UV sensitive security features, which can only be detected only under a UV light, and a tapered serialization. All these features apply to both Form 34A and 34B. Now, my lords, the Commission is to be commended for undertaking this process, because this is their own specifications of what should be in Form 34A and 34B. And my lords, after those specifications were given, the Commission did not stop there. They had a contract implementation report which required them to visit the printer in Dubai, and they had a checklist in regard to these forms. My lords, if you look at page 237, again, the team that went to Dubai made sure that these forms and also the ballot papers, for that matter, contain the features that I've just talked about. Now, our point of complaint in regard to this will be found in Form 34 in our document document number 7, which is marked DN1. And I'd ask the clerks to make them readily available to your lordships. Your lordships, if you look at those forms as given to the petitioners by shipped from Dubai, the inspection that was carried out in Dubai. In fact, if you look at the packaging, the way it was done, and there were constituency and polling stations specific, if you look then at the forms that they have given to us, and even the forms that have been delivered to court through Ms. Guchu. There are also forms that they have submitted on behalf of the respondent. You will find that those forms are actually generated, and they're generated in ways that are different from constituency to constituency, from polling station to polling station. My lords, if you probably have these forms, this volume with you, for purposes of brevity, I could just point out from page 18. Page 18. Yeah. Yeah. Let me just make the general point, because going through this may take a lot of time. If you look at this form, and our position is that they have been generated on an Excel sheet. These are not the forms that had the security features which were imported from Dubai. These are things that were done locally at the constituency tallying center or at the polling stations. And you'll see variously the name of the candidates are switched, because these forms should have been standardized. The names in some forms is Raila Odinga, In others, Odinga Raila. Some, the full name, Raila Amolo Odinga. In relation to Uhuru Kenyatta, in some of the forms is Uhuru Kenyatta or Kenyatta Uhuru. In some forms, they are names of the political parties, which was not a requirement under the schedule and under the regulations. In some forms, you'll find that
you can assist us a lot if you pick, say, one form.
yes.
This is the form with the security features.
Yes.
These others that don't have the security features.
Yes, yes.
That can make a
Yeah,
general...
yes. My Lord, I was just trying to save the time, but let me then, my Lords, ask your Lordships and my ladies to look at page 14 of this document. This is to Nyangasis. DNO1, document number 7. Nyangasi, Oduo.
This one has pages?
Yes, page 104. Yes. My Lord, granted that probably there would have been a mistake about the photocopying. But my Lord, if you look at that, the security features are not there. The serialization is not there because it's supposed to be tapered. If you look at, my Lord, the names, like for example, the name of the first candidate is Okot John Ekuru Longong. That's not the full name of the candidate. If you look at the name of the third respondent, is Kenyat, and then there's Ta, Uhuru. And what follows subsequently is not in accordance with the forms that should have, at the end on page 109, included a collation of the votes garnered by each candidate. If you look at page 109, there is no collation of the aggregate number of votes garnered by each candidate, which, my Lord, you'd find in some other forms. My Lord, then I would want to turn to page 295. My Lord, if you look at that page, again, the security features are not evident, but in terms of the Excel sheet that was used, on the left, my Lord, you'd find what is supposed to be a serial number and the logo, which is the format that the document should have had. But on the top, the way it is organized is not the way it should have been in the forms as printed by the printer who was procured. And my Lord, again, if you look at the names, John Ekuru, Logogogi, Okot, now the names change. And now this one, the name of Raila Odinga, in the previous one it was Odinga Raila, and the name of Uhuru Kenyatta in this one is Uhuru Kenyatta instead of the previous one, which was Kenyatta Uhuru. My Lords, if I take you backwards, on page 95, again you see one which is almost atrocious. Page 95. Now you could see the name of the first candidate Ekuru is A. Ekuru. It's not the full name like the others. And it continues for all the other candidates. Nyaga J. O. Raila. And there are no security features on this one.
Where are the security features supposed to be?
My Lord, they're supposed to be...
Do you have any form with security features?
Yes, I'll show that, my Lord, in respect of... Let me just get... For example, my Lord, in the notice of motion, you'll find a copy at page 482. At 482 in the notice of motion, this is a proper document. The security feature was such that if you photocopy the statutory document, the anti-copying feature would, when photocopied or scanned, come out with this, with the writing copy, 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 like you can see in this one. In the documents.
Yes. Where is that?
Okay.
Because of space, Honorable Rengo,
Yes.
we don't have all those documents.
Yeah, probably I can show this quickly with the one I have. My Lord, in that one, right at the top, you see the barcode, you see the serial number, you see the name of the constituency. The anti-copy feature comes out when it is photocopied. And my Lord, at a later time, we could say if it's a proper form, if you apply a barcode reading machine, it will tell you the constituency or polling station. Yes. So that is a proper form. But in relation to the Form 34B, which we were supplied with by the first and second and, respondents, you'll find that nearly all of them are not standardized. They differ from constituency to constituency. And there are others like Madeira constituency, where the heading of the form is written by hand, Madeira, which was a self-help kind of documentation that was done in that particular constituency. And my lords, if you look at that entire document, you'll find that there were no proper Form 34Bs that were used in the elections. And my lord, we are inviting you to take this seriously, because these forms and the security features were supposed to protect the integrity of the process and the election. And the election doesn't end up with a count. The return of an election is judged by the documents which are in the hands of the first respondent even after the elections, and they are required even to keep them for 3 years. And under the rules, again, you can apply to get information in relation to some of this documentation. So the record is not about the person who won the election. It's for purposes of the principles which are set out in the Constitution: accountability, accuracy, credibility. And my lord, you remember I said at the beginning, all this is being done in the name of the sovereign. It's not being done in the name of the candidates. It's being done in the name of the sovereign. That the sovereign has said, when you conduct the election, you must do them according to the constitutional principles and the law. And this cannot be treated as a minor transgression. So, my lord, I would end up by inviting your lordships also to look at the Court of Appeal decision in the minor Kai matter which I referred to earlier, because I think it sets out in extenso what should happen at the polling station and at the constituency. And they emphasize again and again the instrumentation of the result of that election, which are crystallized in writing out the forms or executed by signing all of those forms. And the judges of the Court of Appeal emphasize that they must be the prescribed forms of the tabulated results, not the results which are keyed, but the tabulated results. Your Lordships, let me end up by saying that the court should stand really firm on the issue of elections, that they should be conducted in accordance with the law. There is no other body or organ which can ensure that at the end of the day, the Kenyan voter, the Kenyan people, have a government formed in accordance with the Constitution and the law. Because Article 33 of the Constitution, which I think is very important, says that a government established otherwise than in compliance of this Constitution is unlawful. That is a very important provision, that the government should be formed in accordance with the Constitution and the law. And, my lords, the Court of Appeal judges in the Judicial Minor KI, they say conflicts surrounding elections and lack of confidence still persist. This is a judgment which was given just the other day. And they stress the history that since 1963, in all the elections, 202, 97, and even 207, they say after every election, there's always lack of faith, lack of confidence. And the only way we are going to cross over the bridge is that anytime there's a transgression of the law of the land in relation to the elections, this court should not hesitate in annulling that election. My lords, if you may allow me to say from the bar, in the recent elections in the United States, when the president of that country talked about the rigging of the elections in the United States, leaders from both parties, opposite parties, said, no, our elections cannot be rigged. We believe in the system. We are waiting for a day in Kenya when, after elections, instead of conflict or disputation, each side can stand up and say, yes, I concede defeat, but I concede because the elections were conducted in accordance with the law. And we've got to put our foot down. If a referee in a football match can put his foot down and make sure those who deserve to win, win, and those who lose, lose justifiably, and a football match ends in peace, Kenya must get there when our leaders and politicians should be in the habit of writing 2 speeches awaiting the results of the election, conceding or making a victory speech. And I think we can get there if we make sure that the electoral process is conducted in accordance with the principles and the law of the land. My lords, I'll now ask my colleague, Mr. Otenda Molo, to proceed with the second component of our submissions. I thank the court.
If it may please, my lords, I will handle this particular segment. My lords, I took the liberty of consulting with the registry, and I indicated to them the key documents I will use for this part. They include 14 documents from our side and some 2 documents filed by the third respondent. My lord, I will refer to the petition, the submissions filed, document number 2, that is the affidavit of Raila, Amolo Odinga, Kalonzo Musyoka, Mr. Wichoi, and Olekina. I will refer to document number 3, the affidavits of Mr. Wamuru and Osotsi. I will refer to document number 4, the affidavit of Dr. Nyangasi, the first affidavit. document number 6. Number 5. The next are DNO 1, which is the main document I'll refer to. Number 7. I'll refer to document number 8, 9, 11, 12, and 13. And particularly, my lords, I will refer to the affidavit of Dr. Edgar Otumba. I will make reference to document number 13, filed by the third respondent, and they are in two different sets. One is detailed as the numerical discrepancies, and the other is the non-numerical discrepancies. There's another set of document number 13 by the third respondent, marked as volume 1 and 2. The second set of documents I'll refer to is document number 14 by the third respondent, volume 1 to 3. But I will essentially cover what is between paragraph 20 and 51 in our submissions. Those particular paragraphs detail some 32 fundamental breaches and irregularities, each of which in our submission, my lord, would invalidate this presidential elections outcome. I have condensed them into 10, so I will not address you on the 32. I'll do it under 10 subheadings. And in each category, my lords, I will not go through the entire raft of issues we've indicated. I will take a sample to demonstrate our point. Now, my lords, I will seek your indulgence in advance that given the volume of documents, I will not expect, my lords, that you will be with me at each stage in opening the document, but I will point out exactly on which document and which page you will find the relevant document I'm dealing with. Lord, I think it is a good point at this stage to start by remembering that we are only a day after celebrating the 7th anniversary of our Constitution. And on that point, my lords, to make 3 quick points. This petition is under Article 140 of the Constitution. The petitioners are acutely aware of the obligations that we have in terms of proving our case. You will hear from the respondents that that is the entire duty that this court is called upon to do. My lords, we wish to submit that there are 2 other parts of the Constitution that are independent of the petitioner and the issues the petitioner raises. My lord, the first one is a right you will not find in most constitutions. What is described as political rights in Article 38, you will not find it in the constitutions of the jurisdictions that you'll be referred to in terms of authorities. It is unique to our circumstances. Lord, it requires and bestows on every citizen a right to fair and free elections where every vote counts. That is what, my lord, makes this petition not about the petitioner, but about this country, as my lords have properly observed in different proceedings. My lord, the other section, article, is Article 81 and Article 88. My lord, these articles place on the IEBC an independent duty to conduct free, fair, and credible elections where there is equality of the vote. That is a duty that is bestowed on them whether the petitioner came to court or not. My lord, I invite you to bear those 3 principles in mind as we proceed with the crux of this petition. Because where I want to start is the petitioner's submissions. Petitioner's submissions were filed on 25th of August. These were filed, my lord, after the IEBC, in accordance with the law, deposited in this court copies of 54,000 returns. we took the trouble to get all those copies and to analyze all of them. The crux of that analysis, which I will not submit on because it will take days, is annexed in 4 parts as appendices to the submission. The first appendix, my lord, marks Appendix A, is an analysis of the Forms 34A provided by the IEBC to this court. The remarks in respect of each is captured. 2 observations on them, my lord. One is that most of those forms are of dubious authenticity. They do not bear even the IEBC stamp itself, and it is provided by the IEBC. My lord, it must be remembered that the IEBC has placed a fundamental importance on its stamp. So much so that, my lord, it declared on 5th of August that any vote that is not stamped is invalid. That letter is page 348 of our document 5. Without their stamp, the vote is invalid. How can, without their stamp, the form be valid? The second issue, which you will see, my lord, is that from an analysis of the petition and the first affidavit by Dr. Nyangasi, the IEBC has clearly made a courageous effort to remedy on the face of those documents defect of what was seen in the initial 34 A's that they provided to the petitioner's agents. The first affidavit of Dr. Nyangasi details all the improprieties in about 29,000 Form 34 A's that were provided to the to the petitioner by the IEBC. Curiously, in the documents they have provided to the court, many of them and many of those mistakes pointed out now appear to be corrected. The conclusion the petitioner derives, my lord, and that is our submission, that the IEBC has subsequently sought to tamper with prescribed documents after declaration of results. And we think, my lords, that that is a serious matter. My lord, Appendix B touches on the question of returning officers. My lord, we'll note that part of our submission was that some of the returns in 34Bs were made by persons who were neither appointed nor gazetted as returning officers. In this Appendix B, my lord, we identify 14 such constituencies. And I will merely indicate because they are listed in order. The first one is constituency number 24, Wundanyi. Number 38, Wajir North. Number 41, Mandera North. 42, Mandera South. 43, Mandera East. 49, Isiolo North. 60, Mara. 66, Mbeere North. 74, Kitui South. 76, Yata. 130, Sigor. 142, Tarbo. 144, Anaibkoi. And 186, Kajiado West. In each of those, my lords, the name of the returning officer which was gazetted is indicated, and the name of the person who signed Form 34 is also indicated. It is our submission, which we have made, my lord, that in accordance with Regulation 3, Sub-Regulation 1 and 4 of the Elections General Regulations 2016, any return by way of 34B that is signed by a person who is not properly appointed and not gazetted as a returning officer must be invalid. Regulation 3, Subregulation 1, and Regulation 3, Subregulation 4 of the Elections in bracket General close bracket Regulations 2016. And if that submission, my lords, is correct, that would affect the validity of 594,476 votes. 594,476 votes cast in respect of the presidency. My lords, Appendix C deals with part of the submission Malane Senior just made to you in terms of Forms 34B deposited in court in respect of the 290 constituencies. I will therefore not dwell on it. It gives the substance of what Malane Senior James Orengo was saying. But let me just only say, without pointing out to the specifics, that there are 5 distinctions that I invite my lord to look at as you are comparing the forms. You will find, my lords, first, that there are some forms which follow the law. They are indicated as Form 34B on the top left-hand corner. There are some without that indication, and yet they are prescribed forms. There are some forms, secondly, my lord, that have a totally different layout, just a visual layout, even in terms of whether it's landscape or portrait, it's completely different, which suggests that they were not collectively printed under the contractual arrangement with Al Ghurair. As to where they may have emanated, I will not go into. Now, thirdly, there are some with the barcode. The prescribed form should have the barcode on the top right-hand corner. The barcode, my lord, and I'll come back to this issue, is what, if you use any smartphone and scan, it will give you the name of the respective constituency. That is the contractual provision. And that is something that even in this court we could do if we needed. As I will later show, my lord, it is a very unique situation that if you run some of those barcodes, and we've captured that in our last Appendix D, and that's the very last document, you will find the returns that are returned are very strange. While some show the name of the constituency, some show you, like the one that comes from Navakolo, that is the barcode of the principal World Health Organization. Some show you, my lord, like the one from Mumias East, that is the barcode for Compare Prise Maro Autotam, wherever that is. And they show all sorts of weird returns. Suffice it to say that the identified documents, the barcodes on Appendix D, show totally strange entities. My lord, the fourth point to note in terms of that difference is the place of handing over. The prescribed forms require that the person bringing the 34As hands over, gives the names and signs, and the person receiving receives and signs. Some have it, some don't. That is a very fundamental feature of the proper form. And the last one, Lord, handing over at where? Handing over in terms of, there's the handing over notes to the constituency returning officer by the presiding officer. And the constituency returning officer also signs that he has received or she has received. And to complete it, my lords, and that is the last, there's a requirement to indicate how many Form 34As have been handed over. Some have this, some don't. My lords, you will have time to look at those distinct features. Allow me, my lords, to go back to the substance of the evidence. My lords, with your permission, I would like to start with the affidavit of Dr. Edgar Otumba. Dr. Edgar Otumba, my lords, is the affidavit dated 24th August 2017. It is a short affidavit of 14 pages with very important annexures, and I want to make 6 points on it. Now, Dr. Otumba is a well-read gentleman with a PhD in applied statistics. Now, Dr. Otumba was contracted and engaged by the petitioner to analyze the stream of results as displayed by the IEBC. He makes very interesting and very startling statements as an expert in that affidavit. A lot will have the opportunity to read it, but he shows 6 things. First, he looked at the results from when they started streaming in, the first batch, on 8th of August at 1943 hours, and analyzed each of the set of results as they streamed in up to 9th August at 1:41 p.m. My Lord, he comes to 6 conclusions. The first one, my Lord, paragraph 8, that the results show a curious trend throughout at each of those entries. And he has annexed evidence of each of those entries by way of the displays from Citizen TV, showing each hour and the display, each hour and the display, from page 2 of that annexure all the way to page 29. And for each of those, it shows a consistent pattern in difference of the votes between Prime Minister Raila Odinga and President Kenyatta of 11%. At each of those stages. President Kenyatta at 55%, Prime Minister Odinga at 44%. The second observation he makes is that if, as by law provided, these results were coming randomly from across the country, then it would not be possible to have such a consistent gap. And for that, he comes to the third conclusion, which he demonstrates, that it is clear that the results were not coming throughout, but they were coming in batches. And that is also demonstrated by their next documents. They were being held somewhere and then released in batches. It is his postulation, my Lord, number 5, that the results were not being streamed from the polling stations because the returns do not show that as by law provided. That this is the result from Kawangware polling station. This is the result from Mathare North 1 polling station. They were coming in batches, and therefore it is not possible to determine from which polling station which results came. And that leads him to 2 fundamental conclusions. 1, that the results were being held and adjusted through what he calls an error adjustment formula. An error adjustment formula. My Lord, he confirms that this formula is as follows, and that anybody in this courtroom or elsewhere who uses this formula will come to the same conclusion. It's a formula of y equal to 1.204. Sorry. I apologize, my Lord. The formula is y equal 1.2045 times plus 183. Yes, indeed, my lord. That is, I am not a mathematician, so I will merely state as they state. Fortunately, in the event that the court needed him, he is also available. Times plus 183, 546. 183, 546. It is his contention, and this is the last bit, my lord, and this is a graph he shows on his affidavit, that using that formula, and my lord, you can see it there, it is indeed times, then plus. Being a mere lawyer, I will not attempt to interpret. But it is his contention that analyzing the results from when it starts to the end, it gives a very clear, straight line, which is a statistical impossibility. He indicates that using that formula, all you need to know is how many votes Prime Minister Raila has at any one time. And the votes of President Uhuru will come out automatically. And that he can demonstrate in court if you wish. With your permission, I'd like to move to the substantive affidavit of Dr. Nyangasi Oduo. And I will refer a lot, my lord, to document number 5. Document number 5. My lord, this document is the one where the original pagination was not very consistent. We took the trouble to give a fresh set just with consistent pagination, and we gave the court 11 copies, both from my lords and the respondents, just for ease of reference. And so without recalling the original ones, my lord, the pages I refer to will be for the repaginated and consistent document. My lord, on that one, we start with the affidavit of Dr. Nyangasi, paragraph 7. And this is on our submissions from paragraph 71, which takes us to the 8th of August at 5:07 p.m. Paragraph 7 of the affidavit and 71 of the submissions. Dr. Nyangasi, that is the start of his analysis, and he swears that by 5:07 p.m., results had started streaming in. He postulates that that is not possible. He postulates that given the requirements of the law, in terms of time of close of voting, which is 5 p.m., in terms of identification of the agent and the officers, in terms of the opening of the ballot boxes, counting of the valid votes and the rejected votes, counting of the respective votes by each of the candidates, entering those votes in Form 34A, causing the agents to sign it, causing any objections to be taken, he postulates that it is not possible that by 5:07 p.m. results could have started streaming in. That is also repeated in the affidavit of Mr. Olekina, which is at paragraph 6, that is in document number 2. And at this point, my lord, it would be important to point out that as this was going on, there was a flurry of activities going on also in Bomas. Mr. Olekina, who was one of the agents of the petitioner, and his affidavit is the last affidavit in document number 2, indicates the things that were going on in Bomas. As I invite you to look from paragraph 6 all through to paragraph 25. He annexes 4 letters, which I think are important, my lord. Actually 5. The first annexure marked A is a letter of 10th August. it points out to the IEBC various discrepancies that they were finding as they were going through the Forms 34A. Annexure B is also a second letter which confirms that by 10th August, this is important, my lord, by 10th August, the IEBC had only received 29,000 Forms 34A. To their credit, they provided copies to the petitioner's agent. However, they did not release all the Form 34As, the images of all the Forms 34As to enable verification. Indeed, by 14th August, and that's Annexure C, my lords, by 14th August, 10,000 Forms 34As still remains unsupplied, 14th August. And 187 Forms 34B were also yet to be supplied. That is the letter of 14th August, Annexure C. The other letter of 14th August is a letter from the IEBC Chief Executive in response. That is Annexure D. And he says the Commission is in a position to provide all the requested Form 34Bs immediately. That is on 14th August. We are, however, not able to supply Form 34As at the moment, but the same shall be availed to you as soon as possible. 14th August, the IEBC does not have all the Form 34As. It must be remembered, my lords, that on the authority of minor KI and the law, the basis of declaration of a winner of the presidential election is the results as announced at the polling station. The question, therefore, will be asked later. On what basis did the IEBC announce a winner on 11th of August, when on 14th August, they do not have all the 34As? Indeed, my lord, the final nail on this matter is the last letter from the IEBC Chief Executive, 15th August, Annexure E. Now we're on 15th August, and it is a very instructive letter. It says, my lord, in paragraph 2, that on 11th of August, the Commission supplied with 29,000 Form 34As, 11th of August, and 103 Form 34Bs. If we pause there, that is 11th of August. Form 34Bs, 103. 34As, 29,000. This is the day the IEBC announced a winner. And the chairman did not qualify his announcement. He did not say, we have received a substantial amount of Form 34As to make us conclude that what we have not received will not make a difference. He did not say that. He said, we have received all the results. My lord, the letter continues. On 14th August 2017, you were supplied with the balance of 187 Form 34Bs on 14th of August, by their own admission. By 11th, they did not have the 187. 14th August, they supplied them. The third paragraph, he says, the CEO advised Mr. Olekina to visit our office today, Tuesday, 15th August 2017, to collect additional forms. Enclosed herein are 5,015 Forms 34As, 5,015 on 15th August. But it does not stop there. He continues, paragraph 5. Please note that all the 40,883 Form 34As shall be made available. Shall, this is 15th. The law requires that the 34A is scanned and sent to the constituency office and sent to the National Tallying Center. And that an SMS in terms of the numbers is also sent. That is what the amendments of 2016 and 2017 require. The chief executive is saying 4 days after announcement of the final results that we shall comply with the law. And he says, so far, up to 35,314 Forms 34A can be found on the public portal. My lords, this is so fundamental that it is no longer an irregularity. It is an election offense. Section 6 of the Election Offences Act 2016 makes it just lawful but illegal of any officer of the IEBC to make a pronouncement that they verily know is false and inaccurate. And we will submit in detail on that later, my Lord. My Lord, the affidavit of Dr. Nyangasi between paragraph 7 to 10 demonstrates a very fundamental issue. And this is corroborated by two other affidavits. The affidavit of Mr. Olekina and the affidavit of Mr. Otsotsi. We have rephrased and restated what they have said between paragraphs 73 and 79 of our submission. And the crux is this: that they were agents and they were at Bomas. And that whereas the results require that once the IBC receives the text of the results from every polling station, they will receive the image of Form 34A, and they will verify that before entering it in Form 34C. That is the ultimate document used to declare a winner of the election. They detail in a variety of ways the fact that that did not happen. They attempted to go through that process. It did not happen. Which in the result, on 11th of August, resulted in them walking out when the IBC refused to comply with the law in that respect. Lord, I will invite you to look at the affidavit of Mr. Osotsi, the second affidavit, paragraph 12 to 15. The affidavit of Mr. Olekina, paragraph 13 to 21. And the affidavit of Mr. Oichoi, paragraph 4, Roman 5. The net essence of their line of evidence, my Lord, is that by the time of declaration of the final result by the second respondent, Mr. Chebukati, there were 10,480 that had not been received. And that leads them to the conclusion and our submissions between paragraph 57 to 61 that the final declaration of the result by Mr. Chebukati, 1, was not supported by Forms 34A. Secondly, and this is important, that the results displayed on national TV as received from the IEBC public portal were unverified. And lastly, in that respect, my Lord, that the result as declared, therefore, was not based on Forms 34A or Forms 34B as required by law. It's instructive to note, my Lord, that the 10,480 Forms 34A outstanding would translate to approximately 7 million votes. 7 million votes out of the 41,883. And Olekina speaks to that at paragraph 22. My Lord, he speaks to the figure on the basis of the maximum number allowed per polling station, which is 700. It cannot exceed 700. Yes. My Lord, let me come to the fourth limb of my presentation, and that is in respect of Forms 34As. My Lord, these are Forms 34As as received from the petitioner's agents. My Lord, I will follow chronologically as presented in the submissions, and therefore I will start from paragraph 22. No, the petitioner's submissions. Yes. And I will make various references to document number 5. But my Lord, specifically, I will start with the document on page 2 of document number 5. That's annexed to DNO 1. But perhaps, my Lord, I beg your indulgence. Before I come to the 34As, let me wrap up the point in terms of the declaration in 1 minute. And that is in terms of the rejected votes. My Lord, the totality of this case shows a very interesting scenario. As you will be shown later, there is no concurrence on the number of votes received by Prime Minister Raila Amolo Odinga at the point of declaration and the number of votes received by President Uhuru Kenyatta at the point of declaration. And where you need to see this, my lords, is merely to look at the replying affidavit by the chairman of IEBC. You will see that he states to have declared each of them with a different figure from the one President Uhuru says was given to him in the certificate he was issued with. These are the affidavits, so I will not speak too much to it, but I think it's a fundamental point. Is it conceivable that the chairman says a different figure from the person he issued the certificate, and that will also be shown. But for now, I want to focus on rejected votes. My Lord, this process displays 5 sets of rejected votes. The first set of rejected votes, my Lord, and this is in Ososi's affidavit, document number 8, paragraph 15 and 14, the tabulation of the Forms 34Bs by the petitioners through Mr. Ososi shows that the total number of rejected votes would be 477,195. 477,195. Same statement is in the affidavit of Omar Yusuf at paragraph 25. Mr. George Kegoro's affidavit also speaks to this from paragraph 81 to 83. According to the IEBC Form 34B, according to the IEBC portal, that is the public website, as at 18th August, the total number of rejected votes was 403,495. 403,495. Mr. Kegoro speaks to that at paragraph 14. 495. That is as at 18th of August. But as at 11th of August, the same public portal indicated that the total number of rejected votes was 401,003. 401,003. The same public portal as at the date of declaration. My lords, according to the ultimate document used by the chairman, that is Form 34C, and a copy of it is in the documents of the third respondent. And my lords will be able to see it. Bring. It is in volume 13, document number 13, volume 1 of the third respondent, page 21, going to 24, and the final result, as shown, is on page 24. The total number of rejected votes was 81,685. 81,685. Now, that's the fourth version. But my lord, 2 points at that point. It is instructive to note that in declaring the winner, the chairman declared the results as received by each of the 8 presidential candidates, but did not declare the total number of rejected votes. And that is a requirement of the law. For only by going through the valid votes cast, the rejected, the spoiled, can one say the total votes cast is so much. And that question will ultimately become important when we are talking about constitutional threshold as to whether any of the candidates met it. But at this stage, it is important to note that. It is also important to note, my lord, that in this very document, and my lords will have occasion to look at it, in respect of 10 constituencies, there is no indication of total rejected votes. So that even the 81,000 cannot be accurate because there's missing 10 constituencies. And that will then be the fifth version of rejected votes. My lords will see that in respect of Muranga, especially Gatanga, there's no entry for rejected votes. Samburu West, none. Soi, none. Emwen, none. Narok North, none. Nyando, none. Kitutu Chachi North, none. Roysambu, Ruaraka, and Embakasi North. All those 10, there's no entry for rejected votes. If the 10 come, my lord, and we don't know what they are, that will be the fifth version of rejected votes. My lord, allow me now to come back to the Form 34A that I had wanted to speak to. And these are samples of the 34As received by Raila Odinga's agents and compared to the returns as provided by the IEBC. My lord, we have provided an analysis of this from page 20 of our submission, my lord. From page 20. And we are going to make a demonstration of only 25 Form 34As very quickly. My Lord, we are going to suggest to you that it reveals two things. One, that there are many and grave inaccuracies and irregularities in those Form 34As, either by negligence and in our submission in most cases, by willful intention. But secondly, my Lord, that those mistakes appear to adopt a consistent pattern of increasing the votes for President Uhuru Kenyatta and decreasing the votes for Prime Minister Raila Odinga. My Lord, the first document refers to Igembe South constituency, a particular polling station known as URAT Buying Company. And in Nyangasi's affidavit, I will cover between paragraph 12 to paragraph 69. My Lord, this would be page 75 of document number 5. Page 75 of document number 5, which is DNO1. My Lord, in that entry, the total votes received by Raila Odinga are 66. My Lord, if you look at how it's translated to Form 34B, which is document number 7 at page 120, my Lord will see that Raila's votes now come back to 56. He has lost 10. And that is in respect of URAT Buying Center, 56. My Lord, I invite you to look at Rabai Road Primary School voting polling station, which is on page 64 of document 5. And to compare it with page 138 of document 7. My Lord will notice that in Rabai Road Primary, Raila had 347 votes. And while President Kenyatta had 132. In document number, in the 34B, which is on page 138 of document number 7, Raila's votes now come to 282, while President Uhuru's votes come to 587. So Raila has lost 65, President Uhuru has gained 454.
Mr. Otiende.
Yes, my Lord.
I don't want to interrupt you, but that is all tabulated in the affidavit.
Yes.
You want to continue your line, fine, but bear in mind that we have seen that it is tabulated. Maybe you want to make your point.
Yes, indeed. My Lord, without referring you to the specifics, therefore, because the pages and all will be shown, I will invite you, my Lord, to take note, and I'll do this very quickly. In Kewi South polling station, Kewi South C, President Uhuru gains 11 votes. In Nyanchenge polling station, which is on page 55 of document 5, President Uhuru gains 11, Raila loses 15. In Rusinga primary, page 56, as compared to page 713, President Uhuru gains 141. No, sorry. President Uhuru gains 8. He had 141, he's given 149. In Amabiria polling station, President Uhuru gains 100. He had 138. The results are given as 238. In Kaptembo, page 83, President Uhuru gains 200 votes. Raila loses 229. In Ilmochio, President Uhuru gains 10. In Kiegoi primary, President Uhuru gains 8. In Kiriana, page 88, President Uhuru gains 2. In Wandiege primary on page 3, Raila's votes are reduced by 1. In Angira primary, page 6, Raila's votes are reduced by 2. In Tonye primary, page 72, Raila receives 561 votes, but 34-1B is given only 2 votes. While President Uhuru did not receive any votes there, in 34B, he's given 517 votes. In Nyabieyo primary, Raila receives 228 votes. 34B gives him 0. In Kiyanka primary, page 86, Raila's votes is reduced from 45 to 0. In Dandora 3 primary, page 90, Raila's votes are reduced by 214. President Uhuru's votes are increased by 212. In Funyula constituency, page 54, the votes cast is shown as 13, and yet the total valid votes are 339. Sorry, let me rephrase that, my lord. Raila is shown as having received 13 votes in Funyula, in that document, yet the total votes cast is 339. In member primary, my lord, and this is in my own constituency. Yes, my lord. In my very own, my lord. And so that the Prime Minister does not think he didn't get votes there. My lord, the Prime Minister had 437 votes, and he's given only 20. And that story, my lord, continues in Karachuonyo, in Mandera North, and we have itemized them. It continues in Nyalenda, Cheptoroi, and a host of others. My lord, for the 25 only that we have selected, it shows a significant number of errors. Which I will cumulatively summarize when, my lord, I come to 34B. So that part of the evidence shows a number of constituencies, over 100 constituencies, where the variations in results show an increase to the third respondent and a decrease to the petitioner. The conclusion in terms of that, my lord, is that these are not errors. These were purposeful mistakes. My lord, allow me to come number 5 to the errors on Forms 34B. My lord, all the 34Bs referred to are documents provided by the IEBC. My lord, I'll make reference to only 12. These are covered in Nyangasi's affidavit from paragraph 71 to paragraph 86. My lord, the starting point is Isiolo North. This is in document number 13, volume 2, at page 1 of document number 13 of the third respondent's documents. My lord, page 1 of this, and that is this big bundle. My lords will look at it later, just to point out without referring you to it. My lord, these are now the Form 34Bs. And on this part, I will indicate the submission and I will indicate the response from the third respondent on that issue. In terms of Isiolo North, it is averred and demonstrated that that particular form adds the third respondent a total of 14 votes. And that is also confirmed by the document filed by the third respondent. Loima constituency, which is on our document number 7, and in page 59 of this third respondent's votes, and this is significant, my lords. In this constituency, and I invite my lords to look at page 68 of the third respondent's document, document 13, volume 2, page 68. We have averred and demonstrated in our document number 7, between page 36 and 40, that Raila Amolo Odinga received a total of 21,058 votes. 21,058 votes. The returns of the IBC gives Raila 11,731. 11,731. He loses 9,327 votes. My lord, it must be remembered that the chairman of IBC used these forms to declare the results, not the 34. Mistake on this one becomes significant. My lord, I invite you to look at page 128, the entries in terms of valid votes. You will see that President Kenyatta had 9,140 votes. That is the 8th column total. 9,140 votes, column 8. The entry in respect of his votes, and is listed as number 5, the aggregate results show that very figure. Kenyatta Uhuru, 9,140. But you will see that in the second last column, the total votes received by Raila is 21,058. But in the aggregate, it now reads 11,731. it is reduced by 9,327. My Lord, number 3 is Rabbi constituency. That is in paragraph 75. And Rabbi constituency admits a very interesting, and this is the beginning of a different trend. My Lord, we had submitted and we will maintain that the law requires that the results are captured in Form 34A, taken to the constituency tallying center, captured in 34B, and then, of course, simultaneously transmitted, so that the result in the prescribed forms are the same result in the public portal that the IBC is required to maintain. My Lord, in most constituencies, and in most constituencies, the results displayed in the IEBC public portal are different from the results contained in their Form 34B. And we've demonstrated that in a number of paragraphs. My Lords, will take note and judicial notice that the IEBC has since said that those numbers on its public portal are mere statistics. That those are mere statistics. My Lord, we will submit that when you are required to post accurate results in a public portal, it is not a statistic. It is a requirement of the law. And therefore, there can be no instance when the results in the public portal are different from the results as captured in your own official document. My Lord, the third respondents consistently in their response introduce a new terminology to that fiasco. Wherever, and that you will see in their response, there is a discrepancy between the public portal and the result from 34B. They have said that that was a transmission error, whatever that means. Transmission error. How the third respondent would know that, I do not know. But in respect of Rabbi constituency, my Lord, and this is on page 138, I will use the respondent volume for ease. Document 13, volume 2, page 138. The third respondent is added 83 votes. In Mara constituency, my Lord, page 140, and I will only give this example. The 34B is signed by a stranger. The person who was gazetted as the returning officer is called Hamisi Halfani Sumo. But the document is signed by a Mr. Obadiah Gashoki. That difference is admitted even by the third respondents. But they offer an explanation on behalf of IBC that it is entirely up to IBC to decide who to engage on any one issue. And that is true. But once they decide, they must gazette that person. If they don't, then those results are invalid. My Lord, Kipipiri constituency. It's on page 147 of the third respondent's document 13, volume 2, begins the very interesting portal difference, where not only are the votes as received by the candidates different in 34B and the portal, the number of rejected votes are consistently different. And it is consistently different, showing a certain pattern on the basis of which the plaintiffs have made a submission, and I'll come to it. The pattern it demonstrates is that invariably, the rejected votes in the portal are always much, much higher than in the Form 34B. And there are about 70 such constituencies. So in Kipipiri, for example, According to Form 34B, only 92 votes were rejected. 92. What does the portal say? 1,087. 1,087. My lords, that difference is phenomenal. The third respondent attempts to explain that that is due to a transmission error. The third respondent. In Daragwa constituency, my lord, page 152, President Kenyatta's votes are increased by 153. And it is interesting that all the other tallies are accurate and correct. The rejected votes shown is 477 against 1,031 in the public portal. 477 in 34B, 1,031 in the public portal. All Jorororok, all Joro Orok. Raila Odinga's votes are reduced by 2. The Form 34B shows 121 votes were rejected. The actual form signed by the IBC chair. But the portal shows 1,233. My lords, I'm mentioning these figures because of the phenomenal difference. If it was 2, 5, 10, it would be reasonable. But the difference of over 1,000 must surely not be a mistake. This continues, my lord, in Tarbaj constituency, page 162. 31 against 475 rejected votes. Uriri, page 164. 125 votes rejected, as for 34B, 1,078 on the public portal. Baringo, page 167. 860 per public portal, 114 as per 34B. Mwala constituency, only 450 in 34B. The portal shows 2,565. 2,565. And all this that I'm mentioning, my lord, are admitted by the third respondent in their response, those differences. Now, the last one actually, is Bureti constituency, Mwala constituency still. The public portal reduces the votes for Raila Amolo Odinga by 21, from 56 to 66 to 56 to 45. And the last one, my lord, is Bureti in this exemplification. My lord, this is on page 182. 182 of document 13, volume 2. And on this, I will close this line of submissions. 34B shows that President Kenyatta received 56,259. 56,259. In the public portal, the votes received by President Kenyatta is is 65,284. That is a difference in terms of addition, my lords, of 9,025 votes. 9,025 votes. Interestingly, the Prime Minister's votes in both the public portal and the 34B is the same, which is 3,106. My lord, cumulatively, the constituencies assessed show an addition to the third respondent of 22,534 votes. 22,534 of those paragraphs covered. And also a cumulative difference in terms of votes, rejected votes of 5,842. My Lord, that is without covering the ones isolated between paragraph 87 and 132 of Nyangasi's affidavit, which also increases the number. That is only from paragraph 71 to 86. My Lord, I'd like to come to Form 34C now.
You have the figure of what your client lost. You've given us what the other one gained. Do you have the figure of what your client lost cumulatively?
Between paragraph 87 and 132, where the figures are not so significant, the gains by the third respondent is 793. The loss by the petitioner is 142. And the variance in rejected votes is 195. That is 81 to 132. The cumulative figure for the earlier paragraph, my colleague will tabulate and I'll give you shortly.
Okay.
Yes. My Lord, I'd like to come to the question of Form 34C. My Lord, a copy of Form 34C has been displayed by the third respondent in its document number 13, volume 1. It's between page 21 and 24. Number 13, volume 1, between page 21 and page 24. Had we had the advantage of receiving in court the original forms as offered by the IBC at this point, we'd have compared whether that compares accurately with their authentic document. But I will use this for purposes of the submissions we want to make. My Lord, on the face of that document, it invites questions as to how the second respondent, that is the chairman of IBC, could possibly have used it as the basis of the final declaration. My Lord, we have received subsequently, and we hope it will tally with what my Lord will receive, a similar form as produced by the third respondent, except in this case now, it is signed by the chairman of the IBC. It bears the names of the candidate's agent, and in respect of ODM, it states declined to sign. If you allow me, and assuming that it is not contested by the respondent, we could use this to compare. If it is not contested, I will make my submissions, and it will be compared when we receive the documents anyway. Yes? But my Lord, as they are looking at it, the first question on it and the documents are the same in both respects. My Lord, I invite you, when you look at the document, to look at the entry in respect of Nyando constituency. It's on page 23 of the third respondent's document I've just referred to. It is constituency number 42. My Lord, the registered voters is shown as 71,680. My Lord, when you go through that document, you will see that the entry in respect of votes received by all the candidates is blank. And this is Nyando, a stronghold of the petitioner. And by a separate affidavit, we have shown that there he received 60,135 votes. 60,135. Here, it is 0. At least the document I'm using and the one produced by the third respondent are similar. They both have 0. It is a fundamental question to ask, my lords, that when Mr. Chebukati stood before the nation and declared that he has received all the results and prepared Form 34C and signed it and gave it to the agent, how could he possibly declare final result when a whole constituency has not received those results? 60,135. On the face of it, my lord, well, I'll use it. My learned friends think that the agent's signatures do not represent their clients, so I will not rely on it. I will be happy to rely on their own document. My lord, I invite you to also look at Turkana West, constituency number 23, on page 22. Again, both documents are the same, but I'll use the one produced by the third respondent. The total number of registered voters, according to the chairman of the IEBC, is 31,416. But the total number of votes considered in making his declaration for valid votes is 49,640. An increment. The total registered voters is 31,416. That is the total number of registered voters. The total valid votes cast and therefore considered is 49,640. 49,640. Well, this is the final document. That is an increment of 18,534 votes, which were not and could not have been cast, but have been considered in the final declaration. My lord, that, and we could, if you go through this, my lord, we have identified, and this is something clerical, so I'll not go through it. Each of the entries, you will find that there are at least 16 constituencies with one or the other form of an arithmetic error on the face of it. But the third very important thing on this matter, my lord, is, again, the two documents that I'm referring to are similar in this respect. The summations on page 24, once you've totaled the votes for each, then the total valid votes cast, then the last column, total rejected votes. No entry on this one. But it is important, my lord, because later we will be talking about, and I think it was already mentioned, the authenticity of documents. My lords will notice that what is on page 22, from page 21, provided by the third respondent, which presumably, therefore, is a document he received from the IEBC, does not comply with the basic security features I talked about earlier. My lord, on the top left-hand corner, there's no reference to which form it is. The one I'm holding shows Form 34C. The one produced does not show which form it is. On the top right-hand corner, the authentic document would show the rule. Like the one I'm holding, Rule 87, Sub-Rule 4B. The one produced does not. Now, it is also materially different, and I'll invite you to look at the one from IBC. The one I'm holding lays out the name of the petitioner differently, Raila Odinga, in terms of layout. The one produced is totally different. You will realize that the one I'm holding, which is the one we received from IBC, lays it in one line. The one that is produced lays it in two lines. My Lord, this might look insignificant, but a prescribed document must be similar in whatever form it's presented. The crux of our observations, my Lord, is that to the extent that the IEBC chairman maintains that this is the document used to declare a final winner, having received all the results, this document is an invalid document, and that declaration is null and void. To the extent, my Lord, that the figures demonstrated in this document are different from the figures demonstrated in its own public portal. The declaration of a winner as done by the second respondent is invalid. My Lord, it is instructive to note, and that's my 8th point, sorry, let me complete that 7th point. My Lord, that difference in figures, and I invite you to look at paragraph 13 of the replying affidavit by the second respondent. The figure he gives, he confirms by affidavit that he declared the third respondent the winner by 8,203 votes, 8,203,290. The third respondent confirms in the 34C that he received that he was declared a winner by 8,223,163, a difference of 200,000 votes. We submit, my Lord, that that difference is significant. The same difference comes to the figures given for the petitioner. The chair says the petitioner received 6,762,224 votes. The third respondent avers that the figure he was given for the third respondent is 6,821,877. Again, that is different. My Lord, that difference perhaps by itself might not be significant except for the next point I want to make, which, my Lord, is the difference between the total votes cast for the president and the total votes cast for all the governor candidates on the one hand, and the total votes cast for all the parliamentary aspirants on the other. And without going into too much detail, my Lord, because this is captured in document number 5, annexure number 6. Using the IBC chair's summations, the total votes cast for the presidency is 15,588,038. 15,588,038. On the other hand, my Lord, the total votes cast for all the gubernatorial candidates is 15,098,646. 15,098,646, suggesting that 482,202 voters, 482,202 voters only voted for the president and not for the governor. For the parliamentary, and we used the Senate only, my Lord, the total votes cast for all the senators is 15,008,818. 15,008,818, suggesting that 567,517 voters, 517 only voted for the president and not for any senator. My Lord, knowing what we know about the law, about the parliamentary practice and procedure, it is not possible. My Lord, I'm coming to the last point, and I invite my colleagues to continue, which are 2 points. That all the results declared by the returning officers who are not gazetted would be invalid, and that I demonstrated. What I didn't talk about, my Lord, is the last bit I now wish to talk about, which is the results from ungazetted polling stations. My Lord, we have submitted and demonstrated that in the midst of all these results, there are results that emanated curiously from polling stations that were not gazetted. My Lord, the gazetted polling stations are contained as annexure number 5 of document 5. It prescribed the polling stations, and document number 27 of our list of documents also has all the gazetted polling stations. My Lord, as you see from paragraph 117 of our submissions, there are a number of stations that returned results, paragraph 117 to 125. Sorry, my Lord, to 123, which were not gazetted. How that could be possible, my Lord, given the prescriptions in terms of the KIEMS machine, given the prescriptions in terms of the law, is difficult to tell. But there's one specific example, and it's in the affidavit, number 12. It's in the affidavit of Mohammed Noor Bare, that is document number 12, and also in the affidavit of Ibrahim Mohammed Ibrahim, document number 13. This gives one specific example, which is, my Lord, that in Mandera North constituency, a particular station was Kalicha Primary School to be the polling station. The parties went to court and the court affirmed it. My Lord, that's annexure number NB1 before Justice Muita. And in respect of this one, which also covered the constituency tallying center, despite the court order, the IEBC still prescribed a different place as the tallying center. The gazette notice, the court order, and a different place is prescribed. So, my Lord, this covers both the polling station and the unprescribed and ungazetted poll tallying center. And that line of submission from paragraph 117 suggests, my Lord, that the results from all those ungazetted polling stations ought to be declared null and void. My Lord, I wish to stop there, and I invite my colleague. My Lord, before I sit, one little clarification on the formula I gave. And it goes with the nature of a non-mathematician like me. When I said 1.2045 times, it is x, not times. That is the formula, x. Yes, it is x. It is, yes, x. If you ask me, it looks like times, but understand it is x. I have been duly corrected. So, y is Uhuru, and X is Raila. That is all, my Lord. Let me invite my learned Mr. Okongo Mogeni.
My Lords, before my learned friend, Senior Counsel Omogeni addresses the court, there is one matter that I need to raise, which is this. When you gave your ruling this morning on the petitioner's application, if you look at paragraph 70 of your ruling, it says, regarding prayer number 7, on the filing of further affidavits arising from the above information.
Could the time be frozen while the point is being made? Yeah.
That is fair. Yeah. It's paragraph 70 regarding prayer number 7 on the filing of further affidavits arising from the above information being obtained, noting the time left for hearing and the determination of the petition less than 4 days, which it is, such an order would not only such an order would only but delay the proceedings, and we see prejudice if the respondents would not be able to respond to the issues raised therein. That prayer is therefore disallowed. Yet, my learned friend Otiede Amolo has referred extensively to the affidavit of Dr. Edgar Ouko Tuba. I appreciate I should have objected at that time. But my lords, you appreciate. Yours was a long ruling. And I had to call for the ruling and go through it and verify that, in fact, you had disallowed that. I should add that all the other figures that my learned friend Otiede Amolo has extensively addressed the court on, we had the opportunity of responding, and when we rise to respond, we will be responding to explain each of those figures. With regard to this, we have had no opportunity to put in perfectly logical, acceptable explanations. And I would ask, in accordance with paragraph 7 of your ruling, the references to this affidavit should be struck out from your proceedings.
My Lord, on record for the third respondent that I associate myself and adopt the submission by my learned senior Poll Petition on that point. I think the record should show that that affidavit should be expunged.
So, from my third and the ruling was led by Honorable Justice Wanjala, dismissed that application. The other application by the first respondent, my Lord, also read by Justice Wanjala, was equally dismissed. And the application by the petitioner to strike out was equally dismissed. It is my understanding that all those contentions that my learned senior now gives copiously were considered and dismissed. Thank you, my Lord.
I think we must make this very clear. In the ruling read by Justice Wanjala, the issue of the affidavits were left to the ruling we delivered this morning. So Otumba's affidavit would go in two places. One, the affidavit in support of the application which we delivered this morning. And then a further affidavit which was supposed to be in support of the petition. And we said in this ruling today, relying on having heard the parties, that it is too late in time to admit those affidavits in support of the petition, noting the time left for hearing of the petition. And therefore, Mr. Muite's point is valid, going to paragraph 70 of the ruling we read this morning, so that in submissions, it will be proper to refer to Dr. Otumba's affidavit in support of the application, but not the affidavit we have admitted. That is the position as far as the ruling of this morning is concerned.
I think we are not. I think then we are duly guided. And we then we adjust our submissions that we refer to that affidavit to the extent that it supported the application, not of the petition.
My Lord, on the same note also, apart from the affidavit of Dr. Twoma, on behalf of the second respondent, in addition to that affidavit of Dr. Twoma, so that we don't come into the same problem again, there are some other three affidavits, which at the
karao, opera kakao. Adonjo karao, wanyono karao, opera kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa. Pembe zote ziwe sawa bila tafasi, bila wazi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao.
Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika. Ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa. Pembe zote ziwe sawa bila tafasi, bila wazi ya badilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika. Ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
adonjo karao, wanyono karao, opera kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wazi yabadilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Mwangaza bila wasitotaka, mabadiliko bila unavyoweza. Tuwe salama, wewe pia wajibika. Ni mtoto wa kika, baba yuko mbele. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao. Twataka nchi ambayo kila Mkenya anashughulikiwa, pembe zote ziwe sawa bila tafasi, bila wazi yabadilika. In the future mavijana si kila saa kushinda njaa. Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao.
Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha. Mwangaza bila wasitotaka, mabadiliko twasawazisha mabadiliko, sawazisha. Twasawazisha mabadiliko, badilisha.
Adonjo karao, wanyono karao, opera kakao. Adonjo karao, wanyono karao, opera kakao.